So what we're doing right now is we are testing our knowledge of the IDEA or special education acronyms that are around the topic of discipline. And hopefully I didn't put some ones on there that I don't know the answer to. So I'm just going to go through and make sure that I actually understand these. And when some of you quicker studies get close to the end, if you want to chime in and let us know that you're finished and let us know how many you got and that type of thing, that would be great. And this will kind of formulate some discussion for us as we move through, and when we talk about some of these things, it'll hopefully expedite the discussion, because we got a lot of ground to cover in a very short time to cover it in. So I wanted to throw that out there, and this is something I've done with all levels of my training, and it's something that helps us to make sure that we are using the same language. It's very important. It goes back to what we were talking about earlier today, in that when you're looking at topics and difficult topics, new concepts, it's very important that you establish the vocabulary in your classroom. And I just wanted to throw this one in here. I like doing this. I flashed up the answers there for a second. Okay, let's move on then, and we'll go ahead and put the first page up. So you can see what these acronyms are, and it's ones that we commonly use, and some are fairly new, some are new language, new speak. So I will grant you that. We in our co-op have talked about manifestation determination, and when you hear national speakers talk about it, lots of times they use the word review. So we kind of added that to it. So the MDR is that manifestation determination review, and that's going to be really the crux of what we're going to talk about today. And I'm going to go on to the next page if everybody's had a chance to capture that. Of course, we'll be sending you this PowerPoint, so you'll have these. So then you have the in-school removals and out-of-school removals, which will also be a big topic of discussion for us today. And positive behavior intervention or instructional supports. And then FAPE, of course, is free appropriate public education. Very, very important that we understand that. And that last one down there, results-driven accountability, is really a push down from the Fed. That's really the centerpiece of their expectations for us, that we have not just accountability, but results-driven accountability, that we are actually doing progress monitoring, and that we're able to say that we've provided these IEPs and these services with some data to support that. So without further ado, we're going to talk about the introduction here. Federal regulations allow for a reasonable degree of flexibility when disciplining students that may have actually violated a student code of conduct. So we do have some flexibility when students with disabilities mess up on your campuses. We do have some flexibility built into the law. We're going to talk about that quite a bit. And then also federal and state data indicate that many students with disabilities do not receive appropriate behavioral interventions and supports. So, you know, and I will reference the letter to colleague from 2016 that OSEP sent down to the state level and started disseminating that amongst the co-ops, in that we want to think about, if things are not working for a student, if if we have a behavior intervention plan in place, if we have students that are emotional behavior disorder, or if we have students that are OHI, we need to keep in mind that first and foremost, we need to try to replace those negative behaviors with positive behaviors. We need to have instructional supports in place through those behavioral intervention plans or those goals, those services that we provide through the IEPs, and we need to have quality IEPs that really push this. So that's not just a best practice. That's actually supported with through the law, and that's something we should all be thinking about and should be doing. And these needed behavior supports per IEP should be implemented with fidelity. We should be, like Doug was alluding to earlier, how difficult it is sometimes for us when we write difficult plans to capture that data. So we need to think about writing a plan that's appropriate for the student, that's rooted in research base, and that has the capability to be measurable. And then also we need to make sure that we are providing a consideration of a continuum of placement options within our schools. We were talking about this earlier in co-teaching, we can't just say, hey, we're going to be all co-teaching, or hey, we're going to be all resource. We have to have all those different placement options from regular ed all the way down to home hospital, and the consideration for moving from those placements and restricting that environment is a big undertaking. And it's something that we need to think about because lots of times we'll have students that have difficulties, they have behavior difficulties, and we maybe we don't have an appropriate tracking system in place in our school or in our school district. And we kind of lose track of what happened with that student. Now, I know we put the discipline into Infinite Campus now, and it's all tracked that way, but we need to make sure that we're keeping up with the fact that students are coming to the office with these behavioral problems, and we need to be reacting to that through the ARC process at some point, well before we reach those 10 days or that 11th day removal that really requires more of us from the law. So we really need to think about that as we move through this. So why special rules for SPED discipline? All too often, it says school officials use disciplinary measures to exclude children with disabilities from education simply because they're different or more difficult to educate than non-disabled children. So going back to what I was talking about earlier, the fact that these letters, these policy guidances that we've received from the federal government have said, hey, make sure that in our codes of conduct, in our handing out of discipline, that we are not disciplining students with disabilities differently than we are other students. It's very important that we keep those things, if there are punitive measures or if there are types of restrictions on their environment, or if we're sending them home, that we're doing that in keeping with how we're doing it with every student, and so that it's not discriminatory. And then when we think about removing them lots of times and sending them home, the research says, and I know I'm repeating here, but I want to get this across. The research says that when we remove them and send them home, that doesn't do a lot for changing their behavior. And as for students with disabilities, we need to be thinking ahead of time. If we start to see these offenses occur, what is it we can do through positive behavioral instructional support that's going to allow them to have positive behaviors replace those negative behaviors? So that's kind of where it all comes from. Avoiding potential denial of FAPE. One of the things that we've brought up is that when we engage in a series of removals, short-term removals, 1 or 2 days here, 1 or 2 days there, and we're removing the student, we're really disconnecting them from their ability to receive FAPE, and that is a big no-no. Okay, so we really need to think about now that are there things that we can do besides send them home. And I know sometimes, like I said, that the policy and procedures require that you send them home. And we're going to talk about those more serious offenses. And we're going to talk about ISS as well in this presentation. So there's things to think about. But we want to ensure that we include positive behavior interventions. We want to ensure supports listed in the IEP are appropriate and reflective of the student's challenges. We want to make sure that those things are being implemented. Failure to implement is one way of when you do get to that manifestation review. If you fail to implement the IEP appropriately and it's caused the student's behavior to occur, then that's a sure way to send that student right back to that placement, and it really ties your hands on how you can discipline them. So we really need to be mindful of appropriate IEPs and appropriate implementation, and make sure that we're capturing the data that surrounds that. Convene the ARC to address behavioral concerns and show evidence of program modification. So if a behavior intervention plan is not working, if a goal for behavior is not working, we need to tweak that. We need to find other ways. We need to try and seek alternatives to whatever it is that we're doing and what we're seeking to do in replacing negative behaviors with positive behaviors. Convene the ARC to discuss parental concerns about their child's behavior and its effect on the child's learning. Communication is key here. We want to make sure that the parents are well aware of what's going on, and we need to let them know about the progress or lack thereof. And we need to be meeting well before we reach 10 days. And I know sometimes that's not what we want to hear, because an ARC meeting is an administrative inconvenience sometimes, but it will be really inconvenient for you if you don't do that and you enter into some type of litigation. So not to be real heavy-handed or crass, but we need to think about what's best for the student. And if those behavioral plans that we have in place, if those goals are not working, then we need to take those short-term steps and really adjust the IEP and make sure that we say that when it does reach, we've got to move this student to an interim alternative setting, or we've got to move this child somewhere to another location, then we have actually shown good faith effort in that we've tried everything. We've exhausted all the things at our particular building or on our campus, and that that we are in fact at a point where we need additional help. And ensure that the IEP is implemented as written consistently and with fidelity. Very, very important. So let's move on. So key points to understand: what are short-term removals? What are long-term removals? Separate the rules for short-term and long-term removals, having the ability to do that. For short-term removals, apply free days analysis and use smartly. And what that means is that you have 10 days to remove the student from the setting. And that's what Jose Martin, who is an expert in the field, he's a special education attorney that speaks at national conventions and things of that nature. He talks about free days a lot. And what he means by that is these are free days as long as we don't discriminate in our assignment of these punitive measures. So we can remove for 10 days. We can remove without any type of notice, any type of idea procedural protection, or any type of services being given. So that's the same for students with disabilities and the students without disabilities. So for long-term removals, it says before removals reach 10, have a meeting. And for long-term removals, manifestation determination is the key. And for any removal more than 10 days, services must be provided. So those are things that you need to know. Those are things that you need to apply and need to think about as we continue to provide good services for our students in our region. So what is a disciplinary removal? A student has violated the code of conduct or received a disciplinary referral from a staff member. An administrator removes the student from the normal setting for discipline reasons. The student is not receiving instruction. Labeling a removal as a mental health or safety related type of removal does not affect the rules. You still have to count them. The student is treated the same as a student without a disability would be treated. And so you just need to keep those in mind. Just make sure that we are applying the same rules to all students. So what counts as a removal? Portion of the school day. Portions of a school day that a student has been suspended may be considered as a removal in regard to determining whether this is a pattern of removals as defined in the KR 300-536 and also the federal regs. So check your district policies and procedures as to what it says about removing for a portion of the day. In most instances, everything I've read, when you remove for a portion of the day, you have to count that. You have to count that, and if you remove lots of times and they're for similar offenses, it starts to look like a pattern. And then when you get close to 10, you need to be thinking about, is this going to be a manifestation? Are we going to be able to remove this student to an IES? What is it that's going to happen? So what counts as a removal? Portion of the school day, we need to really be cautious when we move through that particular scenario. Again, here's some more information on sending the student home early. When we do this regularly, then it becomes a pattern. It becomes something that we need to count. And it's certainly sending the child home early would constitute a disciplinary removal from the current placement. So we have to count that because they're not receiving those services. Now, in-school suspension. In-school suspension count as removals unless 3 conditions are met. If the student is afforded the opportunity to continue to appropriately participate in the general curriculum, and if they continue to receive the services on his or her IEP, and if they are afforded the right to participate with non-disabled peers. The thing that you want to caution yourself about is if you're removing students that have IEPs and you're removing them to a separate place from where you would remove every student, then that could look discriminatory and you want to stay away from that. But as far as ISS is, if you apply this SMART process to it and you continue to have provided the general curriculum access and the student receives services and they can continue to participate with non-disabled peers, then you don't have to count those, and you can really, and the research says that this is much more effective in deterring dropout, deterring students from becoming disengaged and not receiving FAPE. So this is not frowned upon as much as those home removals where you're removing the kid for 10 days without any services. In school suspension, you should have a system in place. And one of the questions that may come up would be, do we have to provide exact services that are on the IEP? And we know that through case law that when we remove students to an IAES, okay, let's say we've removed and we've sent them to another location, we've removed them and put them in a behavioral location, or we've had a serious offense where they have a 45-day removal. We know that services do not have to be exact. However, they need to be close. The intensity needs to be close, and they need to be able to have some engagement with special education teachers. And so you need to have a system in place for your ISS. If you don't want to have to count that as a removal, you need to have a system where if a special ed teacher visits ISS for a part of the day to provide those services, they would have a sign-in sheet, and that they would that there would be a system that they would get that work quickly. They would be able to be seamless, and then you would ask yourself the question too, maybe beyond that, do we have to provide OT or PT? And the answer in the short run is, in an IAES for a long-term removal, yes, you do. You have to provide those specialized services. But to say that you're going to do everything is not required. It's not required in the long term, so we can apply that to the short term as well. So when you're talking about 45-day removals or 10-day removals, long-term removals, we can say the IEP needs to be implemented. It doesn't have to be exact, but it needs to be close to the intensity, and it needs to provide the student the opportunity to have access through accommodation to the general curriculum, and then also to participate with those non-disabled peers. Now, participating with those non-disabled peers and understanding least restrictive environment means that, you know, we need to be, if we have ISS, it doesn't need just to be for special education students. It needs to be for all students. So just keep that in mind. So we look at the unique circumstances in each case. We see, are we providing for in-school suspension? Are we providing services? Are we providing access? Do we have a system in place? Do we have a special ed teacher visiting to provide some of that accommodation, some of that help? If students have a lot, you know, we're talking about students with lots of intellectual disability. If we are placing them in ISS, the intensity on their IEP has to be matched in that ISS removal. So now that's not to say that we have to have a special education teacher in there the entire time, but we certainly have to have some semblance of the intensity of the IEP and capture that, so that you know, and I would say too, at best practice would be to have a sign-in sheet for your teachers, have those special ed teachers visit, have them check up on the students. And then, you know, one of the big pieces that makes this successful is that the students are in fact finishing their work. Okay, so you got to have a system in place for that, so that you can definitively say, hey, we don't have to count these removals, and that gives us some real, and there's some research base behind it. So it's very, very important that we consider this as an alternative to sending them home, you know, all the time, because there is a huge disconnect there. So here's some other considerations. We consider the individual needs of the student. What accommodations do they need to have access to the general curriculum? What supports do they need in their IEPs? What special design instruction is required? Are they having OTPT? Are staff available to support the student as needed to participate in the general curriculum? And what's the percentage of students with IEPs overall in the school compared to the percentage of students with IEPs sent to ISS? Just some things to think about so that you're not violating the LRE requirements, that they're having those types of things that are required, so that you do not have to count this as a removal. Students sent to the hallway or office, generally seen as a short-term removal because the student is not able to participate in the general curriculum. So just be careful with that. Removal to a special education setting in response to behavior or misbehavior. Must consider the circumstances and the component of the student's IEP. If removed as a disciplinary action, most likely will be counted as a removal. If implemented as part of a positive behavior support outlined in the student's IEP, it's most likely not a removal. So that's something else to think about. And how you're just, you know, we said if you can expect it or you can pre-correct it. So putting good IEPs in place to head off some of these situations and including it in the positive behavior support sometimes can give you some flexibility as well. What about bus suspension? Does that count as a removal? If the student has special transportation, then you have to count it as a removal. So let's just read that real quick and kind of gather that in. If bus transportation is part of the student's IEP and no other transportation is offered by the district, a bus suspension is treated as a suspension under the federal regulation because transportation is necessary for the student to obtain access. So again, you're violating their ability to have access to the education. And if the bus transportation is not part of the student's IEP, then you don't count it. So you have some that have special transportation, and I know there's some other reasons for doing those types of things. So you have to be careful with those kiddos, and that's just a one that you want to star and think about when you're going through these processes. So here's the letter that supports that, OSEP Sarzinski letter 2012. If the school is supposed to provide transportation as a related service, the days that a family member provides it still count toward change of placement. So you have to count it as a removal, and it counts toward your 10 days. Not what you wanted to hear today, but that's that is the crux of that. So when you're thinking about removals, if it looks like, sounds like, walks like a suspension, even if you don't call it a suspension, it may likely count toward the 10 days. So we just need to be really, really careful. And we got to have a good system in place if we're going to use ISS and not count it. We have to make sure that we're meeting all those measures. Now, what gets schools in trouble, and the case law supports this, is that if you're just not doing anything. Let's say somebody shows up and goes into the ISS, and you've got a retired teacher running your ISS program, and you ask the teacher, does that student right there have an IEP, or does that student right there have a 504 plan? And you're the police, you're the ISS police. There's no such thing, I don't think. But what I'm saying to you is, if they don't know that that child has an IEP, you're likely to get yourself in trouble. If we're not requiring them to do any work, you're likely to get yourself in trouble. If we're not providing access to the curriculum, if we're not making sure that the accommodations are being made so that they've got those scaffolds they need to have equity in their in their services, then we're probably asking for a problem if someone were to check that. Okay? Any questions? All right, let's move on. So what's a short-term disciplinary removal? A student has violated the student conduct. An administrator removes the student from a normal setting for discipline reasons for less than 10 consecutive school days. Student does not have to receive instruction, and you would label a removal as mental health or safety related. It does not affect the rules. The student is treated with the same as any student would be treated. And rules on short-term removals based on legal precedent. Courts have ruled there should be limits to removals to home and limits to excessive discipline. Out-of-school removals may have limited impact on behavior change. We've already talked about that. No opportunity for teaching appropriate skills. Therefore, school removals in school are favored to allow the LEA to take action quickly and with little complication. Negative behavior may be reinforced. And Jose Martin, or Martin, however you want to say that, the guy's from Texas, he talks lots about students going home and checking on their pets and not doing anything in terms of school work. So just be careful when we talk about out of school, in school, short term, and whether or not they count. So let's consider this hypothetical for a second. Take just a second, if you don't care, and read through this slide and see what you think. See what you think. Hypothetical situation. Maybe one of the math consultants wants to chime in here. I see Stephanie's on here. This might be a little math problem for you.
He's only been suspended for 9 days now.
Right. So in what we've learned prior to this in the presentation, must the school comply with special rules under IDEA in connection with its discipline ability? Do we need to send a notice home? Do we need to have a meeting? Do we need
to have a meeting? You can't get nowhere near that 10 days. I mean, I would have had a meeting, but probably at the 6th day.
But as far as must the school comply with any special rules under IDEA? Probably not, because
not until you get to the
until you reach the 10th, yeah, and the 11th day removal is what
I was just trying to. We work really hard not to get to the 10 days that we try to do. Yeah, we try to make sure that we work really, really diligently, that we don't get ourselves in the position that we've got the 10 days.
And I think the key to that is really showing that your school is in fact doing that. I think that's so key, because so many times I would have, when I was a director, I would have a student maybe having a little discipline referral here and a little discipline referral there, and then they get the big knockout punch where they really do something horrible. We've removed them, and we're really close. Now we can't do what the policy says, right? The policy says it's got to be gone for 5 days if you get in a fight, right, or whatever. And I don't know the policies all that well now. I've been removed for a while. But what I'm saying to you is we got to be really careful. And I think it's very important too that we realize that the government is saying to us, the OSEP, OSEAL, all the folks that oversee us are saying it's so important to have a good IEP, one that provides an appropriate behavior intervention plan. And if we are starting to see these students have some problems, that we need a system in place to catch that and to make sure that we don't get to 27 or 28 or 30 or 50 days of short-term removals, and we've not aggregately thought about it. We've not considered it. So it's good to hear that people are doing that. All right, let's move on.
Denny,
So now,
I have a question.
Okay.
What about those people who are moved for half days? Like they have a problem, they take them home for half a day. So how does that work?
If they're removed to the home and they're not receiving services, my understanding is part of day, end of day removals, you start counting those things, and it's aggregate. So that would weigh in, I would think, to the 10 days. If it was a half day, then 2 half days would make one. So you see what I'm saying? So you would have 20 half days before you would have to have a manifestation. Is that the way you understand it, guys? Okay. Does that answer your question, Steph? That's a good question.
Well, I know that there have been things that have happened at schools, and it's been like 1:30, and school ends at 2:45, and they call the parent, and the child leaves at 1:30. What happens with that?
Well, I think those things are supposed to be entered. Obviously, if they're not entered, it's hard to keep up with that. But they're supposed to be entered, and if there's discipline referrals and there's been a suspension of some sort, no matter the duration, if it's entered in Infinite Campus, there's going to be a timestamp on that, and it's going to, and that's why I'm saying there needs to be a system in place. Someone needs to be keeping up with that at your school. Okay, student A has 3 removals. We got 7 more, you see, but he had 3.5 removals. We didn't capture that one. But then when we go back and look at Infinite Campus, it shows up. So we may have a problem. And what happens is, at the state level, they're bound and determined to oversee this because it's indicator 4A and 4B. And if you go over those and you have a series or a pattern of removals that aggregately amount to over 11 or over 10 days, then there's some things that need to happen. And that's a non-compliance. And especially a non-compliance if you've not had meetings in the interim and tried to adjust those IEP goals and those services and those behavior intervention plans. So certainly that's a very, very, very key piece. But here's long-term removals. Disciplinary removals for over 10 school days, typically alternative disciplinary measures for serious offenses. Your policies and procedures require a removal of this length. Always require the ARC to convene a manifestation determination review and finding of no manifestation if appropriate. The student is treated the same as a student with a disability would be treated as the same for the same infraction, and the school continues to make FAPE available. So the whole idea here is if you have a 10 consecutive day removal, that is a change of placement, okay? And with a change of placement, you must have a manifestation review. And then you go into these, and we've got some attachments to this. You have some, a handout in the Google Drive that has a sheet that takes you through the manifestation determination, and it catalogs each thing that you need to be considering. And we'll talk about that more in depth here in just a second, but I wanted to point that out. Is there's some good resources in there. There's a tracking for those discipline removals, and there's a form in there for considering manifestation determination and what you consider and making a record of that. Now, I would urge you as ARC chairpersons, if you do have a manifestation determination review, to do that within the ARC meeting, because, and I think the presentation says that later, but I would go ahead now and just tell you, that there's going to be some things in there that you may have to do that's going to require some action by the ARC. For example, you may have to get permission to do an FBA, and we know that there was a letter came down from OSEP about that very thing that said if you're doing an FBA as a result of a disciplinary measure, you have to have consent to do that. So that's something to keep in mind. If you're doing a manifestation review, if you do get to that 11th day removal and it's something you just have to do, then there's things to consider, and that's certainly one of those things that you need to consider. The other big thing is, yeah, you're removing that student for 10 consecutive school days. You may be removing them to an interim alternative educational setting, but the ARC still has to make the determination about what services and what location and what setting that's going to occur in, because needs of the student and the IEP drives the services and drives the placement decisions. So you know, my best practice is to say, don't have that manifestation review separate from an ARC. That's what I would say. And I think if you talk to Teresa Combs, or if you talk to Brenda Combs, or if you talk to Jose Martin, or if you talk to Patty Grable or whomever, Dion, they're all going to tell you the same thing. Have that ARC meeting, because there are going to be things that you're going to need to decide. And there's no need of having two meetings. I know no one wants to have two meetings on the same discipline measure. That would be like a nightmare, I would think. So, long-term removals, change of placement. Appropriate if the student's behavior is determined not to be a manifestation of his disability, and the student is treated, then the student is treated as the same. And you can apply those discipline measures. And the school continues to make FAPE available. You have to provide those services. So if you go through a manifestation review as such, and you say, you determine, the committee determines the two questions are, is the behavior related to the disability, or did the system fail to implement the IEP appropriately, and that caused the behavior to occur? And you can answer no to both of those. Then you can apply the same discipline as you would a student without a disability. But then you also, in returning that student to their placement, you need to make sure that there's FAPE is being provided still. So what constitutes a change of placement? Again, I've already said this. Two things. One is a 10-day consecutive removal. When you hit that 11th day, change of placement. You have to have a manifestation review. Or if you have a student that has been subject to a series or subjected to a series of removals that constitute a pattern. And then there's rules that go with that. And it's been hashed out in case law as well. So what qualifies as a pattern? Case-by-case determination. You need to look at how close the removals are to one another. Total days removed is greater than 10. And the behavior is substantially similar. And then what's the length of each removal? How much total time was the student removed? And how close are the removals to each other? Who decides this? The district decides this, not the ARC. So a system must be in place, and you would need to look at your policies and procedures to see this, but there must be a system in place whereby someone, maybe like the director of special ed, would make that determination as to whether or not this constituted a pattern of removal. So the LEA, not the ARC, decides on a case-by-case basis whether a pattern exists, and is subject to review in due process, courts, hearing. Parents can file if they disagree with this. But that doesn't change it. You still are someone in that LEA, the local education agency, going back to our acronym, that would be, for Rachel, the Floyd County School District, would have someone set aside to make that determination. It's not left to the ARC to make that determination, because that could be seen as conflict. So, any questions about that? So here's some important points. The LA determines if a series of removals has created a pattern that amounts to a change of placement. The LEA must identify an individual who will make that decision. And you would just look at your policies and procedures and maybe look at a sample IEP and see, you know, if those removals are similar in terms of the behaviors that are in place. So you'd look at your policies and procedures and determine who's going to make that call. The parent can challenge the school's conclusion through due process or judicial action. All three factors must be present in order for there to be a pattern that constitutes a change of placement. And you should be developing a process to document your decision making. And this is in your packet. The handout's in your packet on page 8 and 9. So you'll find that in the Google Classroom documentation. And there's some case law around this. I won't go into it, but in this first one right here, the court held that several short-term suspensions did not amount to a pattern of removals that equated to a change of placement. The student was suspended a total of 14.6 days for the year, with the longest suspension being 5.4. But the behaviors were not similar, so it didn't meet the measure for, you know, that. State complaint investigator ruled that 3 suspensions totaling more than 10 days did not constitute a pattern because the first 2, 4.5 and 3 days for theft were not substantially similar to the third suspension for a weapon possession. That's tough. That's tough to swallow as an LEA, as a school. But that's some case law that surrounds this change of placement and these aggregated. And I think in Kentucky, we're kind of conditioned to the fact that on the 11th day, you know, that's a change of placement. We're going to do a manifestation review. But there are some instances where that does not, or has not happened in case law. And there are some things where it does constitute a pattern of removal. In this one, the Sage Academy Charter School, state complaint investigator found that a student's 23 removals over a 65-day period constituted a pattern. And the removals were failing to follow directions, cell phone violation, insubordination. So they're pretty much oppositional defiant there. They were just not, they were challenging any authority. So those were similar removals. Each removal was more than 1 day and close in proximity to the other removals. So it met all those conditions. So I'm not going to go any further with that. So in the District of Columbia Public Schools, in a case there, they found a pattern of removals, 4 removals, walking in the hallway, out of the classroom, disorderly in the girls' locker room, disobedient, walking in the hallways. So there was a pattern, and you can see the similarity there. So that's the thing you need to look at, is the similarity. Now this may beg the question, can we go beyond 11 days in short-term removals? I would not suggest you doing that as a best practice. I would suggest that you have those ARC meetings, you adjust those things, and when you do get to that 11th day removal, you have a manifestation because you may get yourself into trouble. Here's another one to consider. Billy's a 7th grader, and you got 6 days suspended for fighting, 2 days in October for violating cell phone, 1 day in February for bringing a small firecracker, 4 days in May for throwing a book at his teacher. Does this discipline that Billy has exhibited create a pattern? And I would say you could argue this one either way, but I would say that this would be one that would probably get my attention, and I would probably say those offenses, while they might not be exactly the same, they're serious enough to consider. And you got 6, 4, 10, 13 days there. So in my mind, it would constitute a change of placement, and you would need to have a manifestation review to see if the behavior was a result or a manifestation of the disability. Okay, so we have some special rules in change of placement. The decision to change the placement of a student is separate from the manifestation determination. Special rules that apply to removals constituting a change of placement. Special rule 1 is that when we change placement, we have a same-day notification to parents and provision of procedural safeguards. So we send the parent rights home, and we let them know within 24 hours of the decision to change the placement. In Special Rule 2, we must continue to provide educational services even if misconduct is not found to be a manifestation of the disability. In Special Rule 3, we must conduct a manifestation determination review, and the purpose is to determine whether the misconduct in question is a manifestation of the student's disability. So we see Special Rule 1, on the date of the decision by the school administrator to seek a removal constituting a change of placement, we must notify the parents within 24 hours and give them their parent rights. Special Rule 2, it's a separation, not a divorce. See if I can get people's attention with that word. It's not a divorce. It's a separation. Must continue to provide educational services. Must continue to provide FAPE. The student must continue to receive educational services that enable them to participate in the general curriculum. All those things we talked about with ISS apply here. Who decides the services? The ARC determines the appropriate services. So again, when you have manifestation, you probably need to have an ARC meeting. Best case scenario, that's what you would do. Services need not be exactly the same or replicate what would have been offered if the student had remained in the school setting, but they need to be close and considered. Manifestation determination review, Special Rule 3. So here's a nice little flow chart as to what you do. If you have a manifestation determination review, you reach the 10 days, change of placement, meeting must occur within 10 days, and the services must continue. So you got to have that meeting, and then you got to provide a written notice, provide the procedural safeguards. You would convene the ARC team, again, in keeping with what we said. You got to review the file and then make those decisions. And the decision is to consider these questions. Was the conduct related to the disability, and was the conduct related to the failure to implement the IEP? So we know already that the MDR must be 10 days, within 10 school days of the disciplinary decision to change the student's placement. So you can't just table that and wait on things and that type of thing. Although there's some case law that say, maybe we ought to wait until we get the evaluation back, or all the data's not in, that kind of thing. So, I would caution you not to mess around with this and to have that because their due process of law says that it should be done within 10 school days. Between the event and the MDR meeting, in the interim between the disciplinary event and the MDR, the school administrator may use up to 10 school days that the statute provides. Who participates? The local education agency, the parent, and relevant members of the IEP team as determined by the parent and the LEA. So again, ARC meeting here. So here's what you got to look at when you're doing a manifestation determination review. When you're looking at these things, attendance records, discipline documentation, teacher observation, current FBA and BIP documents, progress on IEP goals, any previous FBA, all previous assessments, all medical records. Check with the parent regarding any relevant information that may be considered during the MDR. Now, here's one of the things I want to point out, and this is very, very key. There's lots of case law out there that say one thing or the other about considering disabilities that may be secondary to the eligibility disability. So, for example, you may have a student that has OHI and is being treated for ADHD, and we have behavior systems in place, but they're also been found by someone to have a DSM diagnosis of oppositional defiant or conduct disorder or some of those things. Do we consider all of it? Now, the law says that when we do a manifestation determination review, that we should be considering all relevant information. Now, going all the way back to what we talked about earlier, 504 law kind of preceded all this. So it's hard to argue that although some cases out there that have found this, it's hard to argue that that we just consider the eligibility disability as opposed to all disabilities. So, and that one, if you run into that, you know, pick up the phone and call one of us. Let us know and let us hash it out with you. You got 10 days to consider it, but you need to think. And I think the conclusion from Jose Martin is that best practice is to consider all diagnoses. Now, there's some pitfalls with that. You want to make sure that diagnosis that you're considering and including in your manifestation review is valid. And the way to do that would be to say, hey, let us, you know, if a parent brings in, let's say student gets in trouble and the parent brings in something you guys didn't know about at the school level, and say, oh, well, I had a student down here as a mountain comp, and they found that he has conduct disorder. Well, the best practice is to say, well, let us, or they found him to be on the spectrum even, okay? But you don't have anything to support that. First of all, just look to see if you've evaluated that. And then second of all, offer to evaluate. And if the parents agree, then certainly you would go ahead and evaluate and get more data on that. And so in that manifestation review, it's very important that you consider all relevant information. And so I beat that to death, but I'm going to move on here. So we see, and keep in mind too that we've got that nice little form in there for you in your documents. And we would keep all this relevant information in the student's file, including the IP, any teacher observations, any relevant information provided by the parent, all of the above, plus teacher collected data would go into making this determination as to whether or not the behavior was a manifestation of the disability. So we consider all that information. If the decision of the team is challenged by the parent, the team will be better able to defend its decision in a due process hearing if we've documented everything and we've done it through the ARC process. If new information is shared by the parent that has never been introduced until the MDR, the committee must document its consideration of the new information. However, the committee should not be distracted by information that may not be relevant to the issue. So it's one to consider. And if you get side swiped by some new information, you can always stop the meeting and say, we'd like to evaluate ourselves. Now, what does that do for your timeline? Well, that may cause some problematic situations, but you may have to turn that evaluation around pretty quickly in order to make that good review. But most case law says we should be reviewing and taking into consideration every relevant piece of information. The conduct is a manifestation of the student's disability if either the conduct was caused by or had a direct relation or substantial relationship to the child's disability, or the conduct was a direct result of the school's failure to implement the IEP. Now, we can all think of things like, one of the ones that comes to my mind is Tourette's and smoking. Well, we know that the student's got other health impairment for Tourette's. That probably didn't cause them to go down the hall and jewel, right? So that's unrelated. You see that? And then also, if you've got a behavior intervention plan in place, maybe you've got someone that's working with the student, let's say an instructional assistant working with the student, and their job to implement the IEP is to help that student make successful transitions, maybe if they're changing classes. Well, the aide drops the ball and fails to be with that student when they're supposed to be in that transition. The student has an uproar and in the hallway, and then they drag him down to you, and you say, okay, this is the 10th day, 11th day removal. We're going to make a manifestation determination. We failed to implement the IEP. So either question here, if it's a no, then the student goes back to the placement, and you cannot remove for that. So you see what I'm saying? So if the conduct was caused by or had a direct relationship to the disability, or if we fail to implement the IEP correctly, we cannot remove them from their current setting. Is that making sense with everyone? Okay. This term relates only to the definition in the idea and the categories of eligibility for which a student may receive special education services. The ARC may consider additional medical information provided by the parent, but the MDR should focus on the evidence at the time of the event and focusing on the educational diagnosis. Now, that's what most folks in Kentucky would tell you, okay? Focus on that educational diagnosis. Stick to your guns on that. That's what most folks will say. But there's lots of case law out there that flies in the face of this. So what I would say to you is if you have other diagnoses, make sure that they're valid, make sure you've investigated them, and you've taken the time to do your homework on those, because you don't want to find it's not a manifestation of the disability if in fact it is. Any questions? So, failure to implement the IEP. The data must clearly show that a teacher, a paraeducator, or administrator acted in a manner or failed to act in a way that directly caused the student's conduct to occur. Failure to escort the student in the hallway during a transition. That's what I alluded to earlier. Refusal by teacher to allow a student to exit the room to cool down. If that's part of the BIP, then you got to be thinking about that. So your failure to know the contents of the IEP is not an excuse for failing to implement the IEP. So that is a clear-cut situation there when you're talking about making sure we've determined manifestation correctly. Special procedural issues. Stop the MDR and address the deficits in the IEP through the ARC process if the district should have conducted additional evaluations, or the student had a pattern of behavior but no behavior plan was developed, or other major procedural concerns are evident. So that's something to also think about. If the conduct is not a manifestation, the school may apply the relevant disciplinary procedures in the same manner as they would for any other student, non-disabled peer. Except Special Rule 2 applies. What was Special Rule 2? Let's go back to that for a second. We have to continue to provide services. I'm making you guys dizzy. Turn away from the screen. So the school may apply the relevant disciplinary procedures in the same manner as they would for the same duration as it would for non-disabled peers if it's not a manifestation, but we still have to provide FAPE. That's Special Rule 2. So I'm going to skip that. If the conduct is a manifestation, educators can still address the misconduct through appropriate instruction, supports, and services. Include positive behavioral interventions and supports, and the implementation of behavior intervention plans. If the determination is made that the student's misconduct is a direct result of the school's failure to implement the IEP, then the district must take immediate steps to remedy those deficiencies. If the conduct is a manifestation, we must conduct a functional behavioral assessment unless there was one previously done, and or implement and review or revise a behavioral intervention plan. So we have to do an FBA, and note that the letter to Gallo 2013 requires parental consent for an FBA. LEA must return the student to the placement for which he or she was removed unless special circumstances exist or the parent and school agree otherwise as part of the BIP. So that's something to think about. So what are some of the special circumstances that could exist? You can go ahead, in spite of the conduct being a manifestation, if the special considerations are there. And those special considerations are that removal to an IAES for special offenses, for serious offenses, those being drugs, weapons, anything that could cause death besides a 2.5-inch penknife, and also then anything that would cause serious bodily injury. Now, there's some rules around serious bodily injury. I read somewhere in case law where a broken nose was not considered a serious bodily injury, and I think that's been supported. But this is loss of the ability to use your processes, your limbs. It's your inability to manage your pain, disfigurement, those types of things. Rape is one that has been deemed as a serious offense. So those special circumstances, you can go ahead, in spite of the manifestation, and go ahead and have that student placed in 45 days. But you still have to give them services. And the ARC meeting team is the one that decides what those services look like. Do they have to mirror what they were receiving in the previous placement? They need to be very similar. Now, if parent agrees to the change in placement, then you can go ahead and do what the parent agrees to. You do not have to follow. Only these protections only kick in when a parent disagrees with these things. So if you guys can agree on, if you can work with that parent and agree on a change in placement, then it's certainly okay to do so. I think we've reached a point where we need to cut this off. This is, like I said, a big, big topic. I appreciate your attention. I appreciate your time. Are there questions? Anything that anybody would want to ask at this point? Well, certainly we appreciate your time. We appreciate you being here today. There are things in the Google Drive, in the Google Classroom that we shared with you. There's a Q&A that I asked you to read prior to attending this that has a lot of these answers documented for you, a lot of these special situations. One of the things that I failed to mention, I'm going to go back. I'm going to circle the wagon here for 1 second. If you have a student that's in the process, if you have knowledge that a student has a disability, they are still afforded those protections. If you get into a situation where students involved in a serious incident, you need to remove that student, and you have knowledge, or the school has knowledge, the teacher has relayed some knowledge of a series of patterns of behavior to the supervisor in the school or the supervisor at the board office, then those protections, those discipline protections exist for these students. And if you have that happen, you know, it's not a good idea to put off the manifestation determination review, but hopefully you'll have all the data you need to make a good decision. And if you get into a situation like that, where you've got a kid in the process, but then he has a behavior outburst and you need to remove them, please reach out to us and let us find the answers for you and how to proceed. And certainly we wouldn't make any predetermination, but we would certainly provide you some resources, some guidance from folks that we can talk with, and it certainly wouldn't care one bit to do that. You can access me. The email that I'm going to send you with the PowerPoint will have my email address. It will have my telephone number. We're open for business 24/7. If you need us, we don't care for you to reach out. However you need to reach out. We realize you have huge jobs, and we appreciate your interest in special education and the education of all of our students, not just a certain population of students. So we certainly appreciate you being here today, and it's been a great day, and thank you so much. Turn it back over to Dion.
Thank you, Denny. We appreciate that. And again, I would like to just reiterate that we appreciate your time today. We hope that what the work that we've focused on today has been helpful and is useful for you in terms of taking that back and supporting special education at your schools and districts. And if we can be of any assistance to you in any way, we are happy to do so. And on that, the Holler website, our names are on there and our email. So if there's any one of us that you need to get in contact with, you can reach us on that, on those links with those emails. So we appreciate your time, and we hope you all have a great day tomorrow with day 2 of the Principal Academy. So if we don't have any other questions, we'll let you go.
Thank you, guys.
Thank you.